Welcome to What's the Scenario with PLRB, where we explore claims and coverage scenarios relevant to insurance professionals. I'm Brendan McLaughlin, Education Counsel at PLRB, and today I'll be joined by Mike Brode, VP of Meetings and Education at PLRB. So, what's the scenario? During a recreational adult hockey league practice, the goalie skated backward into the crease after a drill and grabbed the top crossbar of the net while stretching and joking with other players. The ice had recently been resurfaced, and the net had not yet been properly secured to the ice. As the goalie leaned his body weight onto the frame, the goal tipped backwards and struck him. In a negligence claim between the goalie and the arena, which team takes the blame? All right, we're going to hop into the scenario here. And first, I just wanted to do a little refresher here. The last time we were here, we were talking about negligence and how you would establish that. And I think we used a baseball analogy then.
Right. Now we're to hockey.
Yeah, you remember those 4 steps?
I think so. So first was to get the first base, a duty owed. And there had to be some breach of that duty to get to second. And then there had to be some sort of proximately caused injury, and then you collect. Was that close? I don't know.
Yeah, as long as you've got those elements of duty, breach, cause, and damages, that'll establish negligence. And we likened it to running around and getting that hitting all 4 bases.
Home run.
But hey, just because you score a point doesn't mean the game is over.
Right.
And that's what we're here today about, is talking about the defenses. So negligence has already been established. You've already, and obviously in litigation, you're arguing it. But, you know, at this stage of the argument, you're saying, okay, let's say they do win and establish negligence successfully, or the jury is convinced that negligence is there. Is there still a defense against it?
Sure.
Yeah. So some of the defenses that are out there, there's a range here. Assumption of risk, contributory negligence, pure comparative negligence, and modified comparative negligence. So
your assumption of risk one would be very apropos for the goalie, because some folks are going to say, if you're involved in a sporting activity and you get injured while you're participating in that thing, you're assuming the risk, right? If you're on little thin skates on ice, bad things potentially could happen. If you're yucking it up with your colleagues and not paying attention to what you're doing, there might be some assumption of risk there, and we're not going to let you collect it all, Brennan.
yeah,
Denying everything. Forget you, buddy. Nothing.
absolutely. You know, that's and this is kind of an older form of doctrine in law. You're thinking about sports is a very common scenario where you see assumption of risk. We have a few in our database. For example, one of skiers assuming the risk when they're running into each other. We also have one out of California. Amusement parks are not responsible for bumper car injuries.
Oh, there you go.
Yeah, right?
You're supposed to run into each other. Yes, come on.
Yeah, it's right in the name.
But not a direct hit so hard. Yeah. No.
Yeah. So here's an interesting question that came up in one of those. Let's say that the player breaks a rule, right? Some kind of foul, or, you know, not intending to injure another player necessarily, but they broke a rule. What do you think about that situation? You think assumption of risk could still apply?
Let's go with high sticking. And yeah, I purposely put my stick up there and tried to lop off the other person's head. I don't know, Brendan. I mean, that might be going a little, that's almost intentional. I don't know if that would be, if I would be assuming that risk, because I'm not thinking another person is going to actually try to injure me with their hockey stick. I don't know.
Sure.
What says the law, sir?
Well, in this case, out of South Carolina, we had a pickup game, a softball. We had a player who was maybe um, outside the rules a little bit, violating a rule, but um, uh, even if they were violating a rule, the court held that they'd still assume the risk. I mean, you get into a game like that, and you are you can kind of expect to be in those situations where
Yeah,
you might get injured.
that makes
So
sense. Yeah, if
yeah.
it's not something so flagrant, then yeah, I mean, you're playing a game. Tempers get ruffled a little bit. Somebody goes out of a baseline or something, trying to make it to the base, gets hurt. Yeah, I'm with you. There's still some assumption that you're still involved in a competitive physical activity. Something bad could happen, and maybe my hockey stick example was way too extreme, but that could happen too, because a different, if that wasn't a South Carolina case, let's say they went cross border North Carolina, another judge or jury might say, here, based on our understanding of it, we're not going to accept that assumption of risk and liability, and we're going to say the person was responsible. You never know how these courts or juries will decide, Brennan. That's the fun of it.
And hockey as well might be a little bit more rough and tumble
Right.
sport. It's got a low reputation.
These guys don't have teeth. Exactly. They're used to having high sticks and
Sure.
teeth knocked out. Right.
Yeah. I will note also we have some case law finding that these older doctrines are sometimes held no longer viable because there's more modern standards where you talk about contributory and comparative.
Yep.
Especially comparative is often enshrined in statute. So some of this older case law you'll find won't apply. So let's move on to contributory,
Sure.
which is still out there. 4 states still have it.
One's still Virginia, and is one still North Carolina?
Let's see. I think it's Maryland, DC, and where did I have that list?
Oh. See, I tried to. As a good attorney, yes, you should have. I should always know before I ask a question to make sure my other side has an answer. Yes, and know what it is. So I apologize. I just say because back in the day, I used to handle liability claims in both Virginia and North Carolina, and at one time they were contributory negligence states.
Well, you nailed it.
Yay.
In addition to Maryland, which we just mentioned, North Carolina and Virginia as well, and also Alabama, and like I said, DC.
Very good.
Yeah.
And those ones are kind of crazy. And I can tell you so by the letter of the law, if I contributed at all towards this thing, so let's go with an auto accident, Brendan, and I was going 2 miles above the speed limit when the other person ran a red light, I think was our scenario back in the other one, and that person impacted my car. Well, somebody would say, well, we pulled your EDR box. We know that you were going 2 miles an hour above the speed limit. That was some contributory negligence. So technically you could be barred from recovery, even though you're like, I was only a mile or 2 above the speed limit. So that's kind of by the letter of the law. If you contribute at all, then you could be barred from recovery. But the reality of it back in the old school days was it was all, even though they called it contributory negligence, they always kind of took like a comparative stance. So you'd have to really do something that was pretty egregious liability wise. So if I was going 25 miles above the speed limit or something, it would have to take something a little more than just a little bit of negligence, just at 1.25% to truly bar somebody by judges and juries out there. They wanted to look for a little more negligence than just, hey, you contributed a little bit, so we're going to bar your claim. So that's where I think a lot of the states then moved towards the more comparative standard, because it's a little easier to interpret, even though it still can get squishy, I guess is the right legal phrase for it, I think.
Yeah, it's a little bit extreme to, totally bar recovery if you're finding any fault on the part of the other party.
Right.
I mean, that's what happened in our scenario is based on Coleman versus Soccer Association of Columbia. The claimant was practicing, grabbed the goal's top rail. The soccer goal wasn't anchored down and ended up, with 3 titanium plates in his face.
Oh, geez.
But yeah, so serious accident. But the jury found the player guilty of contributory negligence and barred him from any recovery. So yeah, it feels extreme, That's why these comparative options,
right,
you see them more often. A little more flexibility for juries.
But then they get crazy too, because you either have, and I can't remember which is which, but there's either the 50-50 rule or the 49-51. So some states say even if you contribute up to 50% towards the total liability picture, you can still recover. Some states say your negligence has to be less than the other person's negligence in order to collect. So you can only collect if you're 49% or less. So the fun part there is you'll see juries play around with that and decide that, because they'll be told what the law is. And so they'll say, well, even though maybe they think it was a 50-50 type of accident, they'll still come down to 49-51 based on whoever they like. So either to let the person recover or not recover based on what they think of the plaintiff in that case. So yeah, a little more fair, makes a little more sense. It's a little easier to argue those points, and juries seem to understand it a little better. But yeah, it still gets kind of iffy and crazy there too.
Yeah. Under that pure comparative standard, that's, the simplest version of the rule. I guess that's why they call it pure. Whatever your percentage, that's what you can recover.
That's what
even if the person who's injured, the person who's suing, is 90% at fault, they can still get that 10% of whatever it is. But
you have the states for that, Brennan. If I remember one, because it always amazed me, was Florida. I think was pure comparative back in the day, but I don't remember anymore. But yeah, again, kind of like contributory. It's pretty rare that there's pure comparative states out there. But
I think we have a state by state on that, so I will refer people to plrb.org.
Perfect.
Just looking it up here, Florida is modified comparative, and that's a 51%. So modified, that's where we get into what you were saying about
51.
Yeah, is it really fair for somebody to
collect if you're 90% responsible? That doesn't seem fair to me, Brennan.
Well, incentivizes litigation, right? You might as well try. You'll get something.
Exactly.
Even if you were mostly at fault, you might as well give it a try. But in a modified comparative, it's a bigger risk for a plaintiff to go ahead if they know they were maybe even mostly at fault, to actually take that case to litigation, carries with it a bigger risk. Yeah. So, it's interesting to see how this comes down when you talk about you get into litigation, you get into negotiations. If you think about it from the perspective of a litigant, there's something of a power imbalance when you talk about you've got this big insurance company, you've got this person who's been horribly injured. Then you've got the insurance company kind of saying, hey, it's this person's fault. So it can kind of be an awkward thing to argue sometimes.
Yep.
And I think plaintiffs are aware of that. Plaintiffs also have the benefit of being able to just kind of focus on the damages amount. Because if you anchor the damages really high, then whatever the percentage shakes out to be, they could be happy with the result.
Or on the cases where you have a really significant injury, sometimes the emotions of that can sway a jury to not say, well, yeah, maybe they contributed towards this thing, but yeah, it was such a horrific injury. And you're right, folks don't, especially a lot of the reptile theory kind of social inflation stuff going out there. If you make the defendant look like a bad person in general, or somebody that's out there that's not being safe and think of the danger to society of this person out there. Yeah, those things can kind of sway jury to not look at the letter of the law when it comes to figuring out comparative or contributory or even pure comparative negligence, and then figure what we're going to award that person something because it's such a horrible injury, and we have to punish that poor defendant out there. So that's a lot of those issues coming up with the reptile theory and those other things are really swaying to the emotion of the jury to make the defendant not look like a good person. And then all of a sudden you take away all those defenses and they just say, we got to punish somebody. Here you go.
Yeah, and that's where, those jury instructions come into play.
Right.
Because those jury instructions are where you're communicating the rules to a jury and telling them what to figure out,
Yep.
Step one being figure out what are the damages, and step two being figure out what is the percentage
Right.
of liability. And so what you're kind of getting at is that sometimes if juries understand what the outcome is going to be, they can kind of game that system and decide what the percentage is based on what they want the outcome to be, as opposed to deciding it based on just purely, let me look at the situation, what is the percentage at fault?
Right.
Yeah. But I think it comes down to, too, your event. It's, we talked about what state are you in is going to depend on what kind of comparative negligence applies. It's also coming down to what's the venue, what is your jury pool like. So it all really comes down to where the case is happening when it comes to these kind of, defenses to negligence.
You're right.
For sure.
A lot of things to look at. Very complex. That's why I enjoyed casualty so much. So it's always, every case is different. So many different elements to take into effect. Oh, it's fascinating to me, Brennan. I really enjoyed it.
Yeah. Yeah. Well, let's take all that complexity and we'll boil it down to 3 key takeaways.
Oh, that'll be fun. Go for it.
Yeah. All right, our 3 key takeaways. A claimant's own unforced errors can dramatically reduce or completely bar recovery in some states. Is it a home game or an away game? The state law and jury makeup significantly impact expected outcomes. And third, where comparative negligence is a viable strategy, litigants can focus on claimant conduct, warnings, and avoidable risks. I will share these the cases that I mentioned in the show notes. So check out the show notes for key points in this episode and links to learn more at plrb.org. Please subscribe and rate us, and we'll see you next time. Thank you. The views and opinions expressed in this resource are those of the individual speaker and not necessarily those of the Property and Liability Resource Bureau, its membership, or any organization with which the presenter is employed or affiliated. The information, ideas, and opinions are presented as information only and not as legal advice or offers of representation. Individual policy language and state laws vary, and listeners should rely on guidance from their companies and counsel as appropriate.